Who are you? And where are you going? What do you want?
Hello and welcome to Trust and Estates Weekly. I'm your host, Kevin Bemmel, and I'm here every Monday at 10 a.m. Pacific time to talk about estate planning and trust and probate administration, primarily from the standpoint of professionals like myself. I'm a professional fiduciary and independent trustee, but also for those of you who are perhaps in your own estate planning process and you want to be able to talk more competently with your advisors, understand better what the issues are so that you can make sure that your own financial situation is being properly taken care of. And so today I'm going to be talking about a situation. It doesn't come up in every estate, but when it does, it poses a set of problems that can be very difficult to handle. And that is when there's a business, in particular, a family business, that's part of the estate. And when there hasn't been any or sufficient planning for what's going to happen with that business when the key person, the owner, passes away. And so I put together a list of about 8 or 10 issues that I think need to be considered based on my experience. I can tell you as an administrator, a lot of my time administrating an estate goes into dealing with a business if there hasn't been proper planning. I will also say that additional time typically does not fall within the standard duties of a personal representative for an estate. And so it can significantly increase the cost of administrating that estate, which of course in the end means there is less left for the heirs. And so if you are a business owner, or if you're a professional and you have clients who are business owners, it is not sufficient merely to include the business as one of the assets of the estate. There needs to be other things done to make sure that the business is dealt with properly, efficiently, and cost effectively as part of the administration process. And that's true. In this case, it's true whether the ownership of the business is an asset in a trust, or whether it's an asset under a will, or worst of all, the owner died intestate. So merely because, let's just take a quick example here. Merely because a business, let's say it's a corporation, and the owner of the business transferred ownership of the stock in that corporation to his trust. Okay, so now the trust owns the business, or owns at least his share of the business. Well, that's fine. The business won't have to go through probate, but merely that it is now an asset of his trust does not say anything about what's going to happen operationally with that business. And that's where the rubber hits the road, to use an old expression, right? If there are clients of the business and they're expecting service, or they're expecting products, and as the result of the owner dying, now some of those processes break down, they don't happen as quickly, so all of that becomes problematic. It can have a significantly negative impact on the operations and the value of the business. Okay, and that's why the personal representative or the trustee needs to step in and quickly get it under control, if for no other reason than to maintain the value of the business. And even if the plan it's decided that the best plan is to sell the business. Okay, and I would add, by the way, that you may designate in your trust that the business is to be sold, but if there isn't a plan for how the business is to be sold, and if there isn't a plan for how the business is to be run while the sales process is taking place, so you're still back to many of the same problems. Okay. Now, if it's some kind of sale arrangement where when the owner dies, it triggers an automatic sale of the business to the remaining owners, and there is a process triggered for valuing what the price of the sale of that interest is. Okay, so now we're getting into the realm where there's been proper business planning. And so little, if anything, that I'm going to talk about today would apply. The problem is there are so many businesses where that level of planning has not been done. And so now what the personal, I'm going to use the term personal representative, that can be a trustee or an administrator. The personal representative is left with a mess and now has to deal with that. Okay, so I'm going to talk about some of these issues, and hopefully that'll make the concerns that I'm expressing clearer. So, whenever there is a business as an asset in an estate or trust, the issue is going to come up of, first of all, is it going to be a taxable estate? Okay. And if you've watched other episodes of my show, you know that just because assets have been transferred to a trust, that does not exempt them from estate taxes. Now, with the passage of the so-called Big Beautiful Bill a couple of weeks ago, the sort of current estate tax regime is staying intact, and so for a married couple, the exemption from estate taxes is, edging up to about $30 million. So it may be that the estate is not going to have to pay any estate taxes. Okay. And so the necessity of understanding the value of the business is not necessary for estate taxes per se. However, like any other asset, the value of the business, or I should say the basis of the business, gets stepped up upon the death of the owner or even one of the owners. So the basis in his ownership will be stepped up. And that can be important because down the line, whoever ends up owning that part of the business or the business as a whole, if it's wholly owned by the decedent, they may sell the business. And so it will be necessary to know, well, what is the basis, or in this case, because of the death of the owner, what is the stepped up basis based on its value as of the date of death of the owner. And so as a result, the business is going to have to be valued. Okay. And the personal representative would typically be the one to arrange that. Now, the issue of a business valuation, it's different than a real estate appraisal, which I think a lot of people are familiar with that. You call it the appraiser. He comes out, he walks through the property, he does his work, he sends you a report, kind of done. Now, with a real estate, with a business appraisal, it's much more like a commercial property appraisal in that the appraiser is going to need books and records for the business in order to properly understand its value. So the methodologies are essentially the same. There's a sort of a market value approach, and there are income based approaches for valuing businesses. Most businesses are going to be valued on an income basis, and that's because what someone would pay for a business is largely based on what kind of income that business generates. Now, it is common, especially if someone is the sole owner of a business, to run expenses through that business that benefit the owner, but are not necessarily relevant in the valuation of a business. Okay, they may be perfectly legitimate from a tax standpoint, but from a valuation standpoint, those expenses need to be excluded. Okay, and so there's going to be a need on the part of the appraiser for pretty detailed income and expense reports on the business in order to understand the income and bottom line of the business and be able to get to a proper valuation of that business. And so it will take more time and effort to get that typically than it does with even a piece of commercial property. The other thing is, oftentimes the end value of the business may turn out to be pretty small. Okay, that being the case, the appraisal fees oftentimes seem very high relative to the value, and it's because there's a certain amount of work that has to be done to appraise that business that has nothing to do with the value. And so, in fact, I had to have a business appraised for an estate I'm administrating, and in the end, I think the value of the business was like, I don't know, $250,000 or something like that. And the appraisal fee was close to $6,000. Now, from a real estate standpoint, that fee is outrageous. You would never see that high a fee on a, even like a little, maybe a little duplex, that sold for $250,000. But the reality it's as much work to appraise that $250,000 business as it is to appraise a $5 million business. The process is the same. The work in reviewing and adjusting income and expense reports is the same. And so from the standpoint of business appraisers, they charge the same amount. Okay. And so this is one of the challenges of business appraising. But it has to be done. And so it will be, right. And there, unfortunately, in general, there aren't a lot of shortcuts. Okay. Now, if a business is very small, and if the IRS is not going to be scrutinizing the business appraisal, so then maybe you can go to a business broker, someone who specializes in selling businesses, and have them do just kind of a rough business valuation. That may be good enough, and that could save money. And for for a personal representative, that may be a better way to handle things, looking at the overall situation. But it is going to be a judgment call as to how such things are handled. Okay. All right. So again, one of the first added problems of a business being part of an estate is there's going to have to be a business valuation, and that's likely to be a more complex problem than it would be for real estate. So okay, so that's number one. Number two, and I mentioned this already, continuity of operations. So in the short term, continuity of operations is probably the most important problem raised by a business that's part of an estate. And the reason is for what I said a few moments ago. Whether the estate decides that the business should continue, whether the estate decides the business should be sold, or the estate may decide that the business should just be wrapped up and closed down. Until those decisions are made, okay, the business should not be allowed to deteriorate. Okay, so for example, the decision to wrap up a business shouldn't happen because there was no continuity of operations. And so by the time the personal representative got around to dealing with the business, there really wasn't any business left. Okay. That is not proper administration of a business in an estate. And so, there's going to be issues of personnel, payroll, clients, customers, contracts, suppliers. All of that is, of course, is going to depend largely on what the business does. But there may also be a leadership gap. Okay. Now, there are many businesses where the owner is really the rainmaker in the business, the one who is responsible for generating all the income. And if that person dies, okay, so now who's going to generate the income? Well, the answer to that may be no one. And that may be why the best decision is to just wrap up the business and not go on, bearing expenses, etc., trying to keep a business afloat that in the end is not viable. On the other hand, the business may be providing services to the estate. Okay. So in that case, the business may need to continue operating at least until the estate can engage another organization to take over those duties. Okay. So let's say that you have an estate that includes in it some sort of horse ranch. Okay, they breed and train horses, right? And look, horses have to eat. They have to have water. They have to be exercised. They have to have veterinary care, etc. So if and in fact, I dealt with an estate like this many years ago. The business had to continue, otherwise the horses would have died. And the business really wasn't any particularly valuable asset to the estate, but the horses were. They were a very specialized type of horse, and they were quite valuable. And so it was necessary for this estate to continue operating the ranch functionally to make sure that one of its most valuable assets, the horses, survived, right? So these are the kind of issues that have to be dealt with, and dealt with quickly by the personal representative, to make sure that the value of the assets of the estate are maintained. Okay. Now, there may be some special court approvals that are necessary to take certain steps. Okay. That would depend on the precise circumstances of the estate, or well, in a trust, that would be much less likely. But that's something a personal representative is going to need to examine as well. Okay. The other thing is, the personal representative may not have the experience necessary to be making decisions about that business. Now, I was not the administrator on this example I gave you with the horse ranch. I was actually the real estate appraiser. This was in another time in my career. If I had been the administrator, as much as I would love to have run a ranch, and I loved that property, I loved being out there, I was not qualified to be making decisions about running a horse ranch. And so, to the extent that the decedent was also the one essentially operating the business, I would have had to bring someone in who had the expertise. Now, I will say, in this particular case, the owner's daughter and I think his son were very involved in the business, and so they took over the operation of the business without their father, once their father passed away, and it was pretty seamless. But that is not always the case. There aren't always people who can step into the place of the deceased owner or the deceased, CEO or whatever, and continue with reasonably seamless operations. And so in that case, some sort of interim CEO with the proper knowledge and experience may need to be brought in by the personal representative in order to ensure continuity of operations. So number two, again, continuity of operations. Okay. Number three. So the personal representative, the executor, the administrator, the trustee, okay, may need special authority to act. Okay, it really depends on, as I was saying a moment ago, the precise situation. Okay, so the court may choose to limit the personal representative's power to run a business, unless it's specifically authorized by the will, or there is a petition to do so, or if it's a trust, the court is not is typically not going to be involved. However, let's take a case where the business is owned, let's say by three people. one of whom has transferred his interest to his trust, and now he dies, and so his trustee is administrating the trust. Okay, now the other two co-owners of the business may dispute whether the trustee has the authority to act on behalf of the business. They may be willing to, in essence, stipulate, well, okay, the trust is now the owner of this share of the business, and as the trustee, you essentially are, acting on behalf of the owner of that portion of the business. But that doesn't mean you can step in and take the place of the CEO who's now dead. Okay. And so the trustee may need to go to court and say, Your Honor, there is no succession plan for this business. And it's not in the best interest of this trust and the beneficiaries of the trust to allow the other co-owners to take over operation of the business without either me or someone appointed by me to have their say as to what's going to happen with business operations. Okay, so again, the authority to act may need to be something obtained from the court unless it is specifically in the documents. And by the way, just because it's in that owner's trust doesn't mean that that is binding on the other two co-owners. So unless there is some sort of business continuity plan developed by all three owners, and that continuity plan specifies that, the trustee of my trust is, authorized to be in my place instead upon my death with respect to operations of the business, it's entirely possible the other two co-owners could object to that. And they would, I'm not a lawyer, of course, as you know, but there may be reasonable grounds for that objection. Okay. This, again, I'm going to be repeating this throughout this show. This is why it is so important to properly plan business continuity as part of an overall estate plan. Okay, let's take a break. When life brings unexpected changes, managing inherited property shouldn't add to your stress. Magnum Properties specializes in probate and trust real estate management. We handle the complexities while you focus on what matters most. From property maintenance to tenant relations, from legal compliance to maximizing value, we're your trusted partner through every step. Magnum Properties, Inc., turning property challenges into peace of mind. Call us today at 213-264-4396 or visit magnumprops.com. Okay, so this is Trust and Estates Weekly. We're talking about what happens when there's a business, in particular a family business, that's part of an estate. And I mentioned before the break, first of all, there's probably going to be a need to value the business, which is going to be typically more involved than valuing real estate, for example. Continuity of operations is going to be a very important issue, especially in the short term. And the personal representative may need some kind of court authorization to deal with the business, especially continuity of the business, if proper planning hasn't been done. Okay, so other issues that are part of administrating a business in a probate or trust. So, business debts may need to be identified. Now, depending on the structure of the business, the debts of the business may not be a debt of the estate. Okay, so in the early days of administrating an estate, at the personal representative may be getting creditors claims. Now if a creditor submits a claim against the estate that actually is against a business, and if that business is a separate entity, let's say it's a corporation, doesn't matter whether it's a C or an S corp, those are separate entities, or an LLC, again, separate entity. A partnership, separate entity, okay? That debt is a debt of the business, not a debt of the estate. Now, if the business was run as a sole proprietor and it was the taxes for the business were paid on a Schedule C in the in the business owner's personal tax return. So now, effectively, the debts of the business are the debts of the estate because there is no distinction between the business and the decedent. Okay, so dealing with debts is a more complex issue when there's a business involved in an estate, but just like anything, those debts need to be identified. They need to be prioritized. Okay. But let's say that for all intents and purposes, upon the death of the owner, the business is rendered insolvent. Okay. And let's say, let's take a business ABC Incorporated. Okay. Not the network, just this XYZ Incorporated. We'll say that some nobody, thinks I'm making an example of any actual company. Okay. XYZ Incorporated. Let's say that with the upon the owner dying, essentially the value of the business drops to zero. Okay. And let's say it had outstanding debts and liabilities of $300,000, but maybe the business has cash on hand of only $50,000. Okay, and the business is not going to be continued by the estate because it doesn't make sense to continue it. Okay, so $300,000 in debts, $50,000 in cash, and in saleable assets, whatever. There's still $250,000 in debts outstanding. Okay, it may not be the case that assets from the estate can be used to pay off the assets of the business because the estate and the business are separate entities. So unless there's some sort of personal guarantee on those debts on the part of the decedent, the estate may not be permitted to pay off those debts. Okay, again, do you see the complexity here? Okay, so there has to be a very clear distinction to which entity has incurred the debts, what assets apply to which entity. All of the very careful accounting of all of that needs to be done. Okay, and to the extent that a creditor to a business that is a separate entity is trying to make a claim against the assets of the estate itself, that creditor claimant may have to be that creditor claim, may have to be fought. Okay, it's generally not within the discretion of a trustee or a personal or other personal representative to pay debts that aren't relative to the entity that they represent. Okay, and in fact, to do so would be a breach of fiduciary duty. It would be no more proper for me as a trustee of a trust to pay the debts of my company than it would be for me to pay the debts of a company that is partially or even completely owned by the trust if there's no personal guarantee of those debts. Okay, so all of this has to be very carefully examined to make sure that there's no breach of fiduciary duty on the part of the personal representative, and to make sure that the heirs are getting their proper inheritance. Okay, that's number 4. Number 5, succession planning or sale. So I've mentioned this a little bit in passing already, but there has to be a determination as to what's going to happen with the business. Now, this issue presumes that what is not a proper business succession plan. The best way to handle this issue is, even if you're the sole owner of a business, to make sure there is a proper business plan. So let me give you an example. Let's say that you have a business, you've always been the sole owner of the business, but you have a couple people who've worked with you in that business for years and years and years. Okay? They've grown up with the business. They're essential to its operations. They're very knowledgeable about the business. Okay? And then you die. What's going to happen to those two people? Okay? Now, there's lots of ways it could be handled. One is the business could be sold, but I would argue morally, if no other way, those two long-term employees should be provided for having dedicated their lives to your business. Okay, and now outside of a provision in a will or a trust or in some sort of succession plan for them to have some sort of benefit upon the sale of the business, a personal representative is not going to have the authority to do so. Okay? Now, another thing is maybe at the time of your death, they're qualified to take over running that business. And so there'll be but then again, a succession plan needs to be created whereby they know that that's what's going to happen, and the representative of your estate knows that that's what you want to happen. Okay. Now, maybe at the point of your death, one of your relatives or heirs is going to take your place. Okay. Now, hopefully that person is qualified. Okay. And won't be viewed by the long-term employees as, someone who doesn't know anything about the business. And gosh, why do they get to come in here and start telling us what to do? We've been here for, 20 years or whatever. All of this should be dealt with in a succession plan for the business. This is apart from your estate plan that's dealing with your assets and all those things. And like any good plan, your estate plan included, which should be socialized with your heirs, a business succession plan should be socialized with key employees. If you have co-owners of the business, it of course needs to be drawn up concurrently with them, right? Because it affects them directly. Okay. That's the best way to deal with this problem. If there is no succession plan, or if the succession plan is unclear or ambiguous or whatever, okay, now your personal representative's flexibility in dealing with this issue is reduced, it's attenuated. Okay. And what options he may have may not be the option that you actually preferred, but because there isn't a proper succession plan is not available to you. Okay. So there may need to be some buy-sell agreements. There may need to be operating agreements. There may need to be shareholder agreements or membership agreements, depending on the type of entity. Okay. All of this should be created in advance as part of your larger estate plan. Okay. If they're not, all of these are going to have to be dealt with by your personal representative. And there's a significantly higher likelihood that the court will have to get involved. And now that takes a lot more time, a lot more expense, can cause a lot of bad feeling. Okay. And so now, here you are. Okay. So succession planning should be a part of your estate planning. Okay. Another issue that I've alluded to a little bit, but I want to talk about in more depth, is the ownership structure matters. Okay. So is the business a sole proprietorship, which means there is no legal distinction between the business and its owner. Okay. The flesh and blood person who owns it is in fact the business as well. And there are lots of sole proprietorships around. Okay. That's as distinguished from a partnership, an LLC, or a corporation, okay, all of which are separate entities from the owner or owners. Okay. Now, they all have their reasons for existing. They all have their different aspects of how ownership works. So, for example, a limited partnership has at least one general partner who has the authority to manage the business on a day-to-day basis, and it has at least one limited partner who is essentially an investor, and their only liability to that business is the extent of their investment. And as a result, they are prohibited from being involved in the day-to-day operations of the business. Okay. The general partner has the authority to run the business on a day-to-day basis, but also has unlimited liability. Okay. So, do you want to be a general partner? Or, was the decedent a general partner? So now this whole issue of who has responsibility for debts comes up again. If he was the general partner and there are debts to that general partnership and maybe they exceed the assets of there are debts to that partnership. It could be a general partnership or it could be a limited partnership. So now, because general partners have essentially unlimited liability for the operations of that partnership, those debts may reasonably be considered claims on that particular decedent's estate. Now, these are complex legal issues, and even as an experienced administrator, I would not be making these assessments on my own. I would be getting competent legal advice because there are lots of nuances in these things. There hopefully is a partnership agreement that spells some of these issues out. Okay, the documents that evidence the debt, that may also have something to say about it. And although I think I'm a reasonably smart guy and I have pretty good reading comprehension, I wouldn't rely solely on my reading of documents to make a determination as to whether the ownership structure either shielded or did not shield an estate from debts. Okay. Even in the case of a corporation, okay, where no one in that corporation has personal liability for the debts of that corporation, at least seemingly so, which is one of the reasons why corporations are formed. That may not in the end be the case. Okay. There may be some sort of personal guarantee that an officer or shareholder or director of the corporation made in order to contract a debt. And so that may, in essence, not literally pierce the corporate veil, but it may change the rights of a creditor to claiming that debt. Okay. Now, that's one of the issues that we've already discussed somewhat. Another issue may be how can the business be sold? Okay. If it's a sole proprietorship, the way the business is sold is going to be different than if it's, let's say, an LLC. In an LLC, the member or the members can sell their membership interests. Presumably, now there may be restrictions on that are in the operating agreement for the LLC. So, for example, there may be what amounts to a sort of a buy-sell agreement in the operating agreement of an LLC that requires, if a member dies, it may say that the member's, spouse or heirs may not take over membership, and indeed, the deceased member's estate is required to sell that membership interest to the surviving members. Okay, so all of these things can happen. Okay, now I should have said this at the beginning, and hopefully it was understood. We're really talking about closely held companies, meaning businesses that are not being traded on a public exchange. None of what I said applies if you own stock in, let's say, AT&T, right? If you just if you you just own 1,000 shares of AT&T stock, or maybe your trust owns 1,000 shares of AT&T stock. Okay, there's no succession planning, right? You just have a small ownership in a huge corporation, and that stock, depending, the estate may hold on to it. It may transfer it to an heir. It may sell it if it needs liquidity. Those are really the only decisions on the ownership of a publicly traded business. But on a closely held company where it's not publicly traded, all of these issues become relevant. Okay, so ownership structure matters. The documents become even more important, even if there wasn't formal succession planning of a business. There may be an operating agreement, or there may be other agreements that weren't done specifically for succession planning, but still could impact how the personal representative handles the business. And so all of those need to be reviewed. Competent advice needs to be gotten, and then the proper decisions made. Okay, let's take another break. Probate and Trust TV, your curated source for the most useful and insightful content on estate planning and trust and probate administration, featuring standout professionals like Bill Gross, Paul Brabelet, James Cunningham, and yours truly. Whether you're a lawyer, accountant, real estate professional, or working on your own succession plan, this channel helps you quickly find the clearest, most practical content YouTube has to offer. Subscribe now to Probate and Trust TV. Spend more time learning, less time searching. Okay, so this is Trust and Estates Weekly. We're talking about what happens when an estate contains a business, a family business, or a closely held business is probably what I should have titled this episode. Okay, and I've talked about a number of points. I'm not going to review the 6 points I've covered already, because I want to make sure I have time to cover the other 4 that I have. Okay. So next is tax implications. So the death of an owner of a business or a co-owner of a business, it could trigger a number of taxes. First of all, as I mentioned toward the beginning of the show, it could trigger estate taxes. Okay, so depending on the value of the business and the other assets in the estate, whether it's a trust, whether it's an estate out that's not within a trust. If it doesn't matter, the trust again does not mean that estate taxes don't have to be paid. So the gross value of the estate needs to be determined. Any debts may be subtracted depending on the nature of the debts. That's for your accountant to advise you on. And then the taxable value of the estate needs to be determined. And if it falls under the exclusion amount, okay, so you don't have to pay estate taxes. But if it exceeds that amount, and if there's a successful business there, it might. So then now estate taxes are due. So that's one issue. And again, because it's more complicated, appraising a business, okay. It does give the IRS more wiggle room to assert that the valuation of the business was not properly done. Okay, and so if you think that if as the personal representative or an heir to the estate, if you're thinking that the value of the business may be the determining factor or may be an important factor as to whether an estate may be taxable or not, so then the quality of the business appraisal and the qualifications of the business appraiser loom much, much larger. Okay, you'd be well advised to find someone who has experience not just in appraising businesses, but in appraising businesses for estates and dealing with them in front of the IRS. Because if the IRS decides to take an aggressive posture, you don't want to be the one where your business appraiser is learning how to handle the IRS. Put it to you that way, right? So that they have experience doing that, will put you in better stead. And in fact, if they have a reputation, look, in the end, we talk about the IRS as this sort of big, huge, amorphous, department of the government, and indeed it is. However, the estate tax unit within the IRS is relatively small. Okay, and after a while, the more experienced auditors, they know who is a credible appraiser and who is not. Okay, so to the extent that you're dealing with someone who routinely is appraising businesses for estate tax returns that are being submitted to the IRS, and hasn't had their valuations challenged, or maybe has had them challenged occasionally, but has always prevailed. Okay, that person, even though they may be more expensive, may be a better way to go in terms of valuing the business. And by the way, the fact that they don't get challenged by the IRS may be a reason for paying them more, because once you get into a level 2 or worse audit with the IRS, now the money that you're going to spend, potential money that you're going to spend defending your position, may far exceed the additional fee that the more experienced and more competent business appraiser would have charged you. Okay, so that needs to be taken into account. Now, with respect to the business, just because the owner died, doesn't mean that all of a sudden the income from the business is no longer taxable. So again, if it's a sole proprietorship, that income is going to flow through to the owner's final personal tax return, and then after that, the income from the business is going to be income to the estate, most likely. If it's a separate entity, so that entity is still going to need to file tax returns. Okay, and if it has, depending on the type, if it's a pass-through entity, the income is going to pass through to the ownership, presumably the estate. If it's a corporation, an S corp, so the entity may need to pay income taxes. Okay, so all of that needs to be dealt with, and all of those tax returns need to be filed. They need to be filed by the proper deadlines. There are extensions available, and you may need them if the early days of administrating an estate are somewhat chaotic. Okay, it's perfectly fine to ask to apply for legitimate extensions. Okay, what's not fine is to just ignore all of this stuff. You can't ignore the tax implications. Okay, and keep in mind, it's not just federal taxes that need to be dealt with. There are state taxes in many cases that need to be dealt with. Now, some states don't have an income tax. Florida, I think, and Texas come to mind. But that doesn't mean that there are no taxes due from these businesses. Okay, the businesses may need to pay property taxes. They may need to pay sales taxes. Okay, there may be other types of taxes. There may be tariffs that they need to pay. The owner dying does not magically make these tax liabilities go away. Okay. By the way, if a business is held, and you would want to check with your estate accountant to be absolutely clear on these. But if a business is held for a certain period of time after the owner dies and then is sold, it might be that capital gains taxes may have to be paid on the sale of that business if there was a gain over and above the stepped up basis for the business as a result of the owner dying. Okay, so there's another tax again, and that could be on both a federal and state level. So the bottom line is you need a very competent estate accountant who deal with estate taxes and other taxes that an estate might have to deal with. Okay, and your regular accountant, maybe you have an accountant who's always done the taxes for your entity, for your business entity, or for the business's entity. Okay, that accountant too needs to be at least somewhat knowledgeable about the impact of an owner dying and may have to coordinate with the accountant for the estate. Okay. The accounting is very much like law. Accountants specialize, okay, and so they don't always know the details of the different areas, and so that's where collaboration will make a big difference. Okay, next, employee and vendor relationships. So this is another thing I mentioned in the very beginning. These have to be maintained. Okay, the death of an owner is likely to cause uncertainty. It may incentivize key people to leave the business because they don't know what's going to happen, or because there isn't a clear succession plan. They're anticipating they're going to get cut out or overlooked or whatever. And so this is something that needs to be dealt with immediately. Okay. Whether it's the personal representative or maybe the lawyer for the business. Okay, if you're the personal representative, or let me put it differently, if you're the potential personal representative, okay, but you have not been officially appointed, you don't have letters of administration, you don't have the authority to act on behalf of the business or the estate or anything, but you can get in touch with the business's lawyer. Maybe it has corporate counsel, outside or inside, and that person may be willing to step in and caution, calmness, restraint, buy you some time until the personal representative is officially appointed, so that some reasonable plans can be made for business continuity, etc. Okay, but I tend to focus on financial issues on my show, but from time to time, the non-financial, the emotional issues loom very large. And this is an area where that is certainly the case. When you're talking about employees, maybe the business, with the owner dead, the business doesn't even have the ability to pay them. Okay, I had that come up in an estate I've administrated, and the business, I didn't have authority to. I was the proposed administrator. I didn't have letters of administration. I asked the lawyer to step in and assure the employees that they would be taken care of as quickly as we could, and as a result, they were willing to hang in there. It was crucial for business continuity. But the same thing can be true of vendors. They're not directly working for the business, but they could be crucial to its continuity. Same kind of issues. Okay, so failure to maintain these vendors, employees, especially key personnel, customers, could all be a big problem, as I mentioned before. Okay, next, licensing permits and legal compliance. So today, depending on the business, there may be numerous permits that a business needs to have to keep operating. If it's a restaurant, there are health permits and fire permits and business licenses and all of that stuff. All of that needs to be maintained, okay? And the fact of the matter is, depending on how aggressive the jurisdiction is and how diligent the owner was in maintaining proper permits, the regulatory authority may be more or less agreeable if, because of the chaos of the owner dying, a permit or a license lapse. Okay, but this is one of those key issues that really needs to be jumped on when the owner of a business dies. In one case, I had a situation where the city dinged the owner of a property. I don't recall why, but I wasn't actually. I had been proposed as the administrator, but the court hadn't officially appointed me, and so I had to ask my lawyer to step in because I didn't have the authority. My lawyer at least could say, my client is in the process of being appointed. There's no one who can act on behalf of the ownership of the property yet. We just need some time to get this set up with the court, and then we will address your issue as soon as possible. And fortunately, the city agreed to sort of hold off on any further adverse action while I was getting appointed, and that was important because cities, and in this case, it was a city, a municipality. They can oftentimes take very drastic steps against a property owner, and that's not for the good of the estate. Okay, and then finally, and this is another one of those emotional issues. The potential for dispute among heirs or co-owners is particularly high uh, when there's a business as an asset to an estate, a closely held business as an asset to an estate. And it's for all of the reasons that I've mentioned. So, you know, when there is not a clear succession plan, where there isn't a sense of what's going to happen to this business, who's going to be involved, who's not going to be involved. Okay. So you may have a business where one of your children is involved with that business and has been, a large part of its ongoing success. And you may have another child who's never spent a day in his life being a part of the business, right? And now you're dead. Is it fair, as much as I don't like that word, is it fair that the business would be potentially split 50-50 between the son or the child who's worked, and made a substantial contribution to the business, to split equally that child with the child who's never had anything to do with the business? Is that reasonable? Is it going to look reasonable to the child who's been working in the business? On the other hand, if you decide to give the business to the child who's been working in it, is it fair that the child who's getting nothing, does that look reasonable to that child? Right? So all of these issues need to be thought about. They need to be discussed. Decisions need to be made. Those decisions need to be socialized with the people impacted by those decisions. Okay, that's true of heirs. That's true of co-owners. All of this needs to be examined, needs to be talked about, and needs to be boiled down to a succession plan. People will deal much better with a succession plan that's in writing that they may still think is unfair than no succession plan, and decisions are made, purely on a financial basis, which is what in the end the personal representative will probably have to do, and then not take into account any of the emotional issues involved. People are much more likely to feel hurt in the second case, and much more likely to take action as a result of that hurt. And so this show is first and foremost about avoiding a situation where these kinds of disputes arise among heirs, among co-owners, etc. Okay, and that's the message I want to leave you with. If you own a business, whether outright or with co-owners, get your succession plan done. Get with your lawyer, get with your accountant, get with the other people who are involved in the business. Get this figured out, okay? And in that way, avoid a lot of potential problems. Okay, so thank you so much for joining me today. Love to see my live viewers on. Tomorrow at 10 a.m. Pacific time is my show, Business Lessons from the Military. I hope you'll join me for that. And then on Wednesday at 10 a.m. is my show, People Making Money. So I hope I will see you later on in the week. And once again, thank you so much for joining me. Wishing you a wonderful rest of the day. Real quickly before I sign off, if you have any questions, comments, links to social media will be in the show notes when this episode posts on YouTube. So please, love to hear from you. And last, before sign off, if you like this show, and you know of someone who could benefit from it, please tell them about it and encourage them to watch it or listen to it. Would love to have them do so. And I would very much appreciate your help in spreading the word. So once again, thank you so much for joining me, and signing off as I always do. Marie, darling, you are my belle. Courage at all times, my friends.